promoting mediation, and educating everyone about old age method of solving disputes. Sixth Summer School of Nivaran was inaugurated by none other than Honorable the Chief Justice of India, Honorable Mr. Justice B.R. Gawai, on 31/7/2025, who lauded Team Nivaran for doing a tremendous job in field of mediation and recognition of Supreme Court mediators in international forums. We are indeed privileged to have Ms. Adamya Raj as a guest speaker on this fourth day of 6th Virtual School of Mediation. The name Adamya is very meaningful. It denotes indomitable, unconquerable, formidable, and brave. It signifies a person who is strong, resilient, and cannot be overcome or subdued. Ms. Adamya Raj is a distinguished mediator with over 6 years of experience in dispute resolution. She specializes in property disputes and also brings her expertise to a wide range of civil and commercial matters. As the head of mediation at Radanks Limited, London, she leads with vision and integrity, shaping mediation practices both within the organization and on the international stage. Radanks Limited is a UK-based mediation and conflict resolution organization known for its global network of accredited mediators and its commitment to inclusive, timely, and effective dispute resolution across borders. Ms. Raj was a team member for Radanks International, representing only international mediation expert Dr. Renu Raj, a committee member of the 2023 Mediation Bill Amendment in the Indian Parliament, chaired by late Mr. Sushil Modi. She has also been written and published books and articles, especially introductory titles like Mediation in a Nutshell and Fundamentals of Mediation. An internationally recognized trainer, Adamya has designed and delivered acclaimed mediation programs across jurisdictions, contributing meaningfully to the global advancement of alternative dispute resolution. Her work reflects a deep commitment to promoting dialogue, resolving conflicts, and strengthening the future of mediation worldwide. Alongside her mediation work, Adamya brings a wealth of practical experiences in managing legal compliance, supporting property matters, and facilitating both community and corporate events. Her multicultural fluency and sharp attention to details consistently drives efficiency, innovation, and inclusivity in all her professional efforts. With a keen eye for pinpointing improvement opportunities, she has consistently implemented strategies to bolster customer experience and optimize business efficiency. Ms. Adamya is a motivated professional with a knack for thriving in dynamic, fast-paced environments and fluency in multiple languages. She is proficient in English, Hindi, German, Czech language, as well as sign language. Ms. Adamya today will speak on negotiation, types and methods of negotiation. As we are all aware, the alternative dispute resolution has existed in Indian society since ancient times, and dispute resolution through community dialogue has been a long-standing practice. The concept of calling panchayat to settle a matter is both a proverb and a deep-rooted cultural tradition. In present day, negotiation, mediation, and arbitration are being recommended more often for settling common workplace disagreements between parties instead of always depending on court litigation. Negotiation plays a significant role in the working life of every professional and individual in society. Negotiating is often the most flexible method of solving disputes compared to arbitration and litigation. Human beings are diverse with different tastes, preferences, needs, and values, which can be in conflict at times. Consequently, negotiations become a necessity for living a life of peace and prosperity alongside others in the family, community, department, organization, and society in general. Negotiations are therefore and indispensable to our progress as persons, cultures, and nations with clashing viewpoints. values, ideals, and ideologies, governing our behaviors and relationships with our fellow colleagues across all boundaries. For progress, which requires peace to take place, we need to negotiate towards win-win outcomes. Besides making business deal, effective negotiation practices can have many other uses as well, such as conflict resolution strategies among various nations or opposing parties. Negotiations are an inevitable part of our human reality, and each person will eventually have to negotiate important issues at some point in life. People negotiate constantly with almost everyone within their lives. Without open and transparent negotiations, human society and civilizations would not be where they are today. In fact, we negotiate not because we want to, but because we must do so to achieve progress and results in a peaceful manner. Negotiation requires planning, goal setting, strategizing, gaining agreement between parties regarding the main issue to be negotiated, collaborating, practicing the skills and various techniques, and closing the process with a win-win agreement. Negotiation is a strategic discussion intended to resolve an issue that both parties find acceptable. Negotiations involve give and take, where one or both parties will usually need to make some concessions. Even if a solution is not arrived through negotiations, parties do not lose anything. They could try to negotiate later on, even if dispute is before the court. Moreover, element of anatomy in negotiations and mediation is a key attraction for parties to try alternative dispute options, since the option of court litigation leaves little room for independent choices. Now, I hand over floor to Ms. Adamya Raj. Welcome, ma'am. Over to you.
Thank you for that lovely introduction. Thank you so much, Sunita.
You're welcome.
What I'm going to do is I'm just going to quickly share my slides and then we can start. Great. So obviously, because today's seminar is about mediation being the main topic of discussion, so we're going to talk about negotiation in mediation and the different types of methods that can be used by mediators. My name is Adamya, as Sunita has already said. So a little bit about Radanks. We're an international mediation and legal firm which are dedicated to advancing the practice and professionalism of mediation. We are very firm believers in, oh my God, sorry. We're very firm believers in how mediation should be the first choice of dispute resolution opted by everyone before going to any form of other dispute resolution services like litigation, which is more predominant. Radanks was founded by Dr. Renu Raj, who was the only international mediation expert who was invited to the Indian Parliament and who also contributed to the amendment of the Mediation Bill 2022, which later was implemented as the Mediation Act 2023. And as Sunita said, I was one of the team members who also participated and accompanied Dr. Renu Raj to the Indian Parliament for that reason. We offer multiple accredited training programs, consultancy, community engagement, and we are the only firm that offers and delivers sector-wise mediation training and conduct cross-border mediation training. We are recognized by international mediation councils like Civil Mediation Council in the UK, and we partner with multiple institutions across the globe to promote ethical, inclusive, and effective dispute resolution. So obviously, Sunita's already talked about how we use negotiation on our daily lives. Everyone uses negotiation. It's very common. You can simply go shopping, and shopping in itself is the most common form of negotiation that is used. You could be shopping with your fruit seller or your vegetable seller, and you could practice basic negotiation with them. I'm still going to go over the basic definition of how negotiation is, where two parties will communicate their aims of what they're hoping to achieve at the end of the process, and everyone puts forward their best foot forward to say, this is what I want at the end of this process, at the end of this negotiation. And eventually, through multiple discussions, there's a mutually acceptable agreement that is reached. It involves multiple different proposals being shared, different interests, and ultimately, for a successful negotiation to take place, that both parties are going to compromise in some way or the other in order to reach a mutually acceptable goal. Negotiation within the mediation process, just to talk a little bit more, in the UK and in most parts of the world, mediation is used in a very facilitative manner. So that being said, most people, mediators, act as a neutral party who only facilitate the process. They do not jump into the process. They act more like a catalyst who only work towards successfully helping the parties reach a negotiated agreement. And it's a very structured process where the mediator is going to help both of the parties reach best negotiated agreement. And of course, in order to reach a resolution, negotiation is the core activity that will be taking place. So a lot of the times when I am training budding mediators and novice mediators, they often confuse having the knowledge of negotiation with partaking in the mediation process and taking away the power from each of the parties if they know about negotiation. But actually, if a mediator is aware of how negotiation works, they can facilitate the mediation process a lot better by asking the correct questions and help facilitate the negotiation between both the parties and guide them without actively imposing their own thoughts and decisions on either of the parties. Negotiation can occur jointly in an open session or privately in caucuses where you can explore Bhatna, Vatna, or the different interests and emotions, which is something that we're going to talk about more in detail on a later slide. So a mediator in the joint session or the private session can help either of the parties clarify their interests, their priorities. When we talk about interests, that has to be separated from the need for a party. For example, if I was to put that in layman terms, food and water is need. And then food and water, when it comes to branded food and water, for example, if someone says, I will only have Evian water, that no longer is a need, that's an interest. So as a mediator, we need to help the parties identify without losing our neutrality on whether they're asking for that negotiated agreement out of an interest or is it really a need? Because that will help facilitate the conversation and the mediation a lot better in a positive manner. You help the parties generate and evaluate different options, and you can help them move from their fixed positions, at which point they'd come, to a more collaborative and problem-solving method. So why do mediators really need to understand negotiation? Like I already said, mediators need to understand the negotiation process in order to help be better facilitators. They can manage the process a lot better. They can know when to call in for joint sessions, when to call in for private caucuses, or go into complete private sessions. It also helps the parties think more creatively on what their solutions could be, what their available solutions are. Every mediator has a different style of mediating, and I have often observed this through different role plays that we organize and through different training courses that I hold, that a lot of the times mediators tend to take a backseat because they think as a facilitator, they're just passing the message, being a postman from one place to the other, and they don't actively partake in the mediation process. They don't ask the correct questions. They don't help the party reach alternative solutions. And that's because there's a lack of understanding on the negotiation process and why a mediator needs to actively know on how the negotiation process can benefit either of the parties. So when a mediator understands negotiation in and out, they will be able to empower the parties as well so that they can reach their best resolution. Of course, we all know that at the end of mediation, there's no guarantee for us to reach 100% satisfactory rate. It's never going to be a win-win situation. It's always going to be more or less a win-lose situation where you're going to win some and you're going to lose some if you're one of the parties participating in the mediation. You're going to walk away 50% happy with the outcome, but 50% dissatisfied. But at least that 50% that you've achieved is going to be based off of what you wanted. And a client who partook in the mediation will only be satisfied with that outcome of the 50% if they had all of the knowledge and the correct negotiation strategies with them, and they were equipped well by the mediator with those tools. That's what differentiates you being a good mediator versus a bad mediator. It's not the positive outcome of the dispute resolution, but it's more about how that positive outcome was reached through the correct negotiated methods. So to understand negotiation, we need to understand the key principles. Obviously, there has to be there has to be some form of voluntariness, where participation is by choice. Mediation as is a participation by choice. Even if it is court mandated, it is still a choice. If a party walks away from mediation, which they are allowed to do, it's not good. It might harm the ultimate decision during the litigation process, but it's still a voluntary process. They can feel free to accept or reject any proposals being put forward to them. So it's not something that is set in stone. It has to be in good faith, the engagement. There has to be, either of the parties have to have the willingness to listen. They have to be open to the communication and be willing to work towards a resolution. Sometimes parties, when they come into mediation, they come in with a block. And again, I cannot emphasize this more, a mediator's understanding on the negotiation process can also help clear those blockages that a party might have to then further their want to listen and negotiate towards a resolution. Of course, deception and manipulation needs to be avoided when any deal is being negotiated, because that helps build the good faith and trust in the process. So if one party is being dishonest in their procedures of negotiating, the mediator, without losing the neutrality, can step in to try and direct them in the correct direction. Because at the end of the day, the way I see it as a mediator's role is also like an adult who's just guiding two people who've lost their way somewhere along the lines in this conflict zone, and you're just guiding them towards the correct direction. So always maintaining good faith during the process ensures that the process carries forward. There has to be mutual respect for either of the parties. And this is something that comes from power imbalances during the mediation process. If there is no mutual respect between the parties, then they won't be able to negotiate a mutually satisfactory deal or an acceptable resolution. It could be because if the whole point of not reaching a mutually satisfactory agreement would be that maybe one party will then default in satisfying what was already agreed upon, despite it being agreed upon, and could also call for there's being some discrepancy during the mediation. So it's very important for a mediator to keep all of these factors in mind when they're facilitating the process, to ensure that there is mutual respect when the negotiation is being communicated as well. So, which is why it is very important for the mediator to actively participate in treating all of the parties equally, giving them equal amounts of time, giving them equal amounts of opportunities to express themselves, to put their negotiating deal forward. And at the end of the day, the mediator needs to help the parties focus on their interests, not on their positions. So sometimes parties will come into a mediation and they will say, I want £10,000 as compensation. And they will be rigid on wanting £10,000 or wanting to go to the court. Sometimes novice mediators or seasoned mediators would say, okay, well, if you're not willing to move from your position, then I guess this is it. There's no other way out. But if you would push a little bit more further, we can then explore why that £10,000 is very important to this negotiation. Why is that the most important thing to achieve for this particular party, and why they're not willing to move? And that's how you can help them explore their interests. And maybe perhaps that £10,000 might be a need for that negotiated deal, and might not just be an interest, might not just be a position. But without having that conversation and exploring those options, we will not, as a mediator, you won't be able to facilitate the mediation forward in a positive manner. So when you focus on your interests and not positions, so I'm going to go back to this basic example of Evian water, because Evian water is worldwide known to be one of the most expensive brands of water. And a lot of people, when they choose to have bottled water, they consider having Evian water as a status symbol in many parts of the world. So if someone wants bottled water, we have to explore why it has to be Evian. Is it their interest? Is it just their position? Sorry, this is a weird analogy, but that's the analogy I'm going to be using. So is that to explore their interests of why it has to be that particular brand of water that they want. It could be that maybe they, based off of how their tolerance is, Evian water is the only water that they're comfortable drinking without getting sick. It could be multiple reasons, but without exploring that, we won't be able to reach a best negotiated agreement, if that makes sense. Obviously, there has to be confidentiality when negotiation is being done. There has to be trust, because if a negotiated deal is being explored with a mediator in a private session, so if party A is discussing their multiple options of where they will be willing to, how far they will be willing to negotiate, that has to be done in a very confidential manner. Sometimes I compare the negotiation process like playing the game of poker. You don't show all of your cards all at once. You only show them when the time is necessary. So this is up to the mediator as well to help the parties identify on how important it is to them and how quickly they will be willing to explore their ultimate negotiated strategy versus how many steps they'd like to take. So sometimes, for example, a party would say, do you know what? My position is £10,000, but I'm willing to negotiate down to and accept £6,000. But I don't want party B to know that yet. I want to start at £10,000 and see maybe if the party agrees to £8,000, but I'm willing to settle for £6,000. Sometimes mediators confuse that, and I have seen that in our role plays where mediators would say, okay, but you're willing to accept 6,000, so why do you want to extend this more? Why not just accept £6,000? Again, that is, while that is a valid question and it's a valid way to explore the interest of why the party wants to wait to finally settle for £6,000, it could be that they might say that maybe party B will accept a little less than £10,000 and he will still come out of it a little bit more successful, rather than coming back with £4,000 less, which is £6,000. All of the parties should be able to make an informed decision when they're negotiating. So they need to know their rights, the options that they have available to them, the consequences of each choice. And that's when a mediator will play the devil's advocate and discuss that. What if this is an unsuccessful mediation? What would happen if it goes to court? All of these, while they might not seem like they're part of the negotiation, they actually are exactly the same questions that are asked when negotiation takes place. There's two types of negotiation. There's positional negotiation and interest-based negotiation. So in positional negotiation is where there's bargaining being done over a fixed amount, something that they have settled on, but now they're just trying to, like my example, someone has settled on 10,000, wanting £10,000, but they're just trying to negotiate either a little less than £10,000 or a little more than £10,000, but that £10,000 would be the fixed amount. Then there's interest-based negotiation, where it focuses more on the underlying needs and talks about the difference between the position as to where someone is versus why they are at that position and why is it that important to them. Interest-based negotiation has, both of these types of negotiation have their pros and cons. With positional negotiation, it's a very clear and structured style of negotiation, because you know, okay, this is the fixed amount. This is the fixed position, rather, that it's not just money, but this could be the fixed position. It could be that I'm going to get promoted to said position in a workplace, and that could be a fixed position of negotiation. But it's a very clear and structured way of negotiation, because you know that it's around this one particular thing that the negotiation has to take place, because that one thing is not going to change. It's not a variant. And it's good, and this is more useful for one-off disputes, something that it's more useful for more corporate disputes as well. Sometimes I would say when everything has been agreed upon and they're just trying to decide on the amount. Mostly this happens when it comes to monetary compensation. That's when it's more common, when there's positional negotiation. But it can lead to dissatisfaction, because there hasn't been a lot that has been explored in terms of the positional negotiation, because we're just negotiating that one particular aspect. We haven't looked, it's like a horse with the blinders. You're not looking any other direction except for this one particular topic of discussion. An interest-based negotiation helps build relationships, because it leaves room for understanding between both of the parties. It helps achieve more durable outcomes, but it requires more time and more transparency from either of the parties. And sometimes it can be misused by one party if there's some form of power imbalance during the mediation as well. So it could be that one party recognizes that they have a more upper hand and could misuse the interest-based negotiation to get a much better negotiated agreement in their favor, as opposed to the other party who probably hasn't figured out the correct way to negotiate it for their own benefit. So there's different methods of negotiation. There's competitive negotiation, where the focus is more on claiming the value, and it leads to high demands, pressures, and there's little space for any form of concession. So it's, for example, if two parties are trying to negotiate a business deal with each other, then the competitive negotiation would kick in when it comes to monetary compensation, because they would talk more about, each party would want their own benefit. The party who is using the service would want to get the cheapest, best deal possible. The party who is providing the service would want to get as much money as they possibly can from the person they're providing the service to. This collaborative negotiation, where it focuses more on open communication and problem solving, where I'm going to go with the same example of a service provider. It could be possible that a service user would say, actually, do you know what? I'm a startup. I don't have that much money to fund this website design. We're going to talk about website design. So it could be that a website designer is the service provider, for example, and the startup company is the service user. They could say that I don't really have the facility to pay this full amount yet. So they could come up with a collaborative negotiation method of having set up a payment plan. And they could say, okay, because you're a startup, we're happy to think about different ways of coming up with a payment plan. And you could, stagger the payments that come through, and you can still achieve what you want. I will still design the best website for you. But obviously, it's a more collaborative problem solving when it comes to the payment for it. And then there's compromise, which is a more midpoint approach. It's not always satisfying long term, because when you compromise to reach a resolution, there is no guarantee of you feeling satisfied. You will always feel like you could have gone that extra mile, but you didn't, or you were forced not to. So I would never suggest compromise being the first choice of method of negotiation. Then there's obviously avoiding or delaying tactic. This is something that is used quite often when we used to play team sports back in high school, for example, football or basketball. It could be that if you've got one goal in, you will then delay the other person achieving another goal in order to ensure that you've achieved what you want to achieve without letting the other person achieve it. It could be used by someone when there is a power imbalance in the room of the mediation, and someone force their opinions and continue delaying the mediation process. And this is more likely to happen in a court mandated mediation because they would have achieved attending the mandated mediation process, but they will ensure that they delay or avoid negotiating to the best negotiated agreement so that they can get their day in court. So it's for them, that's the kind of negotiation strategy they've used. They've used the avoidant and delayed negotiation strategy. Then there's accommodating negotiation strategy, where one of the parties or both of the parties just want to maintain an amicable relationship. So they just want to reach a form of agreement which is not too detrimental to either of the parties. So they're willing to be more peaceful about it, and they're willing to just let it go. And I have actively seen mediations and participated in mediations where one of the parties just wants to have a more amicable relationship, so they're willing to forego a more aggressive negotiating strategy. And sometimes it is seen in power imbalance disputes as well, where it's not always seen in power imbalance disputes, but it could be sometimes seen in power imbalance disputes as well, where one of the parties who's a lot more introverted, a lot more meek, or is not very comfortable, or is not aware that they can negotiate to this point, they will then be more accommodating towards the negotiation because they wouldn't have all of the knowledge. They won't be equipped with the knowledge that this facility is available to them. So it could be, in a power imbalanced example dispute, it could be that a big corporation is being sued, for example, by someone who was a victim of one of the products that they used, but doesn't have access to such high-end lawyers. So in that scenario, a high-end lawyer, quite oftenly used, could basically pretend like they have more options available because they have more access to money and more power, that they will be able to get a better negotiated deal if it goes to court. So in that scenario, the victim of this particular situation would accept a lower negotiated agreement as opposed to what they potentially could agree on had they been able to negotiate using all of the knowledge of negotiations properly, or if it was a mediation process, having the mediator facilitate negotiation correctly. So a mediator's role in negotiation is very, very simple. You just have to support the interest-based frameworks. You don't have to lose your neutrality as a mediator during the negotiation process. The way that you can do this is you can use the reframing tool from your mediator's toolkit. What I call it's like imagining a mediator has a toolkit. So you pull out the reframing tool from your mediation toolkit and you help the parties reframe their demands, their positional demands. Positional demand being the one that they started the mediation on. You can help manage power imbalances if you, as a mediator, are able to reduce the power imbalance. There will never be 100% power balance between either of the parties ever. Theoretically, it is possible, but practically it isn't possible. There will always be a time where one party would probably be 5% more powerful during the mediation process or more vocal during the mediation process than the other party. But that difference between the power imbalance is more acceptable and more you can work more with it, as opposed to there being a massive power imbalance where someone is constantly having from the mediator. And again, it's not always done aggressively. It could be done in a very quiet and calm manner as well. So it is the mediator's responsibility to ensure that the power imbalance is managed as well. And once that has been done, it will open up the room for either of the parties to try and brainstorm and generate more options for themselves. Obviously, I talked about BATNA and VATNA before. So BATNA is the best alternative negotiated agreement, and VATNA is the worst alternative negotiated agreement. These two are one of the best tools that a mediator can pull out midway through the mediation, which is a very common point of discussion that is discussed when normal negotiations happen as well, because either of the parties need to think about, if they don't achieve what they thought their best negotiated agreement would be, what is their option B? What is plan B? in life, when we think about anything, we always think about if plan A doesn't work out, there will always be plan B. Lots of people have plan C and plan D. Lots of people have multiple options that if this doesn't work out, there's the next option, vice versa. And some people, they don't. Some people don't think about it. Some people are very focused and they streamline their entire focus on plan A. So it's very important as a mediator to help them think about what the possible plan B could be and to explore plan B, which is BATNA, which is the best alternative to the negotiated agreement. Then there's WATNA. A lot of people don't think about the pitfalls. A lot of the times you would see this in a imbalanced mediation where the more powerful party who has a lot of money, a lot of time on their hand, and good lawyers would say, you know what? I don't want this mediation to go ahead. Whether the mediation is positive or not, or whether we're able to successfully resolve this through mediation, I have a strong lawyer. He will get me what I want in court. It's very important as a mediator to explore their worst scenario outcomes, which is what now, which is the worst alternative to the negotiated agreement, because there's no guarantee in the litigation process, as we all know, and a lot of the lawyers who are attending the session would also know, you aren't always guaranteed what you go for in the courtroom. So if you've gone to the courtroom saying, I will get this as my compensation, you're not guaranteed that. You're not guaranteed what you have gone to achieve in the courtroom. And that's something that a lot of the people aren't fully aware of or don't think about. So it's very important to discuss that as a mediator and explore this. Once you explore BATNA and WATNA with either of the parties, you will be able to reach ZOPA, which is the zone of possible agreement between both of the parties. And that's the sweet spot. Once you have acknowledged that both of the parties have reached a zone of possible agreement on point A, for example, it will be so much easier to facilitate a mutual agreement and a resolution between the parties rather than trying to help them constantly negotiate with each other. So as a mediator, your role should be to try and help them discuss their mutual zones of possible agreements, also discuss their partners and WATNAs, which will help them further reach the zone of possible agreement. Some of the common things that mediators can find themselves doing wrong could be they could obviously not achieve the correct negotiated agreement by saying that I'm supposed to only be the facilitator, so I'm not going to jump in and not going to ask the correct questions to either of the parties, which facilitates and allows for the wrong negotiated agreement to carry forward. When I say wrong negotiated agreement, bear in mind, of course, as a mediator, you're not expected to make that judgment or that call on whether this is the correct way on how they should achieve this resolution or not. But it is your responsibility as a mediator to ensure that they have all of the available knowledge to them, all of the tools available to them to have reached that agreement so that they satisfactorily walk out of that mediation. And that's it for my presentation.
Thank you so much, Adamya, for your insightful lecture. We gained a lot from your vast experience and knowledge. So we would like some questions to be some questions have been put by our members. So the first question is, how is the midpoint? This is from Mr. Siddharth Patra. It is, how is the midpoint defined in the context of the compromising method of negotiation? Is it established by the mediator, or does it emerge on consensual views of the parties to a mediation process?
So it is something that is established by both of the parties in the mediation process. It could be established by a third party when it is not mediation. But in mediation, the midpoint of the negotiation is established by both of the parties participating. But the mediators alertness and attentiveness in the mediation process
Yes.
is what is going to identify that midpoint. Because it's not going to be the party's responsibility to identify that they've reached the midpoint of the negotiation. It is still going to be the mediator's responsibility to identify it, but reaching it would be on the party. So it's going to be a little bit like teamwork. I
Okay.
hope that answers your
Thank you so
question.
much. So the second question is, this is by Lenny Rahman. The question is, voluntariness is one of the principles of negotiation, participation by choice, even if it is a court-mandated mediation. Can you elaborate further?
Yes. So you can't deny going to the court if you have been called for a litigation process. But if you've been asked to mediate by the court, at least in the UK, you can say you don't want to go for the mediation process and you would rather opt for the litigation process. So it
Okay.
is while mediation is voluntary, you are still allowed to say no, I do not want to partake in the mediation process. But if it
Okay.
was litigation, you can't say no. If you've been summoned by the judge to come to court for a litigation, for a case that or a dispute, you have to show up, but you don't have to show up for mediation.
Okay. So Mr. Rahman does it. Next question is from Miss Abha Sharma. She says, what is the effect of Batna method on the outcome of negotiation?
The Batna method allows for there to be less rigidity between both of the parties, and it allows for you to reach a resolution rather than leaving it at a blockage and saying, right, we were not able to find a resolution, so let's go to litigation. Whole point of why mediation is more predominant in the dispute in the legal industry at the moment, and why everyone is pushing for mediation, is because it's a very effective way to reach a resolution and still maintain amicable relationships with each other. So if you're
Yeah.
going to be able to explore the BATNA between, like, or help the parties as a mediator explore their BATNA with each other, you can
Yeah.
help them not reach that bitter point of having to then go to litigation, wait for years. It doesn't matter what part of the world you are. The legal systems are very backed up, and mediation is the boon of the legal world at the moment. So if you're able to help them reach their partner, they will be able to reach a negotiated agreement, because it's not the worst outcome. It is still their best alternative. It's their plan B. No, a lot of people who go with plan B are still happy with plan B. It might not be plan A, but you are still happy with plan B. So that's the benefit of BATNA and exploring BATNA.
Okay. So thank you so much. And the next question is, how can a mediator identify the ZOPA during mediation when parties are reluctant to disclose their true bottom lines?
ZOPA is the last step and the last item you need to identify as a mediator. Never try to push for reaching the ZOPA. And this is sometimes as a novice mediator, a common mistake, not just as a novice mediator. Seasoned mediators can also sometimes make that mistake, because we are in a rush to reach a resolution. We're excited for the resolution. It's a very common human behavior. Sometimes it happens to me as well. I can be very excited to say, okay, great, parties are happy to reach the resolution. But we must not focus on the ZOPA at the get-go. You have to first focus on getting those two alternatives. Only then can you identify the ZOPA. So don't be in a rush. ZOPA is it's the last step before you reach the negotiated agreement, of course.
Okay.
So if someone is being reluctant, try and work on reaching those alternatives and work on reaching that discussion, as opposed to trying to figure out what the ZOPA is. It's let the parties come up with their own ZOPAs once they've discussed the alternatives.
Okay, thank you so much. Now the next question is from Ms. Sangeeta Mehrotra. What is the option left in a matrimonial mediation when one party just doesn't go on a path of mutual separation or divorce, but despite staying outside the matrimonial house?
So to understand, to reframe the question, what you're saying is, if someone wants a divorce, if someone is
What
living
is the
separately, but they're not willing to go for mutual divorce, irrespective. Okay.
despite staying outside the marriage for 4 years or so, presses upon
Despite living in
resolution of
separation.
rights. So they don't,
Uh,
the question is that they don't want to go for, they don't want to stay either together, they want to separate, they don't want to separate, they don't want to divorce, and they press that they want restitution of conjugal rights.
Okay, so in that scenario, you need to explore their interests and needs. Why is it that they are wanting that? A lot of the times, wants are confused with needs, but they're very two different things. I can want to have food every single day at a Michelin star restaurant. I'm so sorry, a lot of my analogies are food related because it's the most common
Yeah.
analogy, an easy to understand analogy.
Must
But I can
be.
want
Must
to
be
eat
affordable.
it is a very easy analogy to understand, but I can want to eat every day at a Michelin star restaurant,
Yeah.
but that is not my need.
Mm.
So I have to be asked if I'm going to be rigid and say that I want this particular thing. Why? Why do I want it? My favorite question as a mediator to ask anyone partaking in a dispute resolution process is why?
Okay.
Why? What? How? When? These are great questions to ask, and it doesn't put you in a place of bias either. You don't lose your neutrality if you just ask why. Be inquisitive. Be a child. Say why. Why don't you want to leave? And that will be your answer.
Okay. Thank you so much. Now the next question is from Prisha Vaswani. It is, what can be certain key differences between mediation and negotiation and conciliation in order to understand each of these processes separately? And are these processes in any manner interrelated?
Conciliation and mediation are quite interrelated because conciliation is a little bit more like evaluative mediation, where the conciliator will have some form of opinion and guidance, active guidance and participation in the process. Whereas in a negotiation, there really normally isn't a third party involved. In conciliation and mediation, there is a third party, which is a mediator or a conciliator. Both of their roles are different. Mediator across the world normally is a facilitative one, which doesn't really get actively involved in the mediation process, and they're more like a catalyst. Conciliator is more, they will give some form of opinion or try and tell you on how to resolve it or the correct way to resolve the dispute. Whereas if it's just a negotiation, normally a third party is not involved. There's no third party who is facilitating that negotiation. It's just directly between the parties who are negotiating the deal.
Okay. Thank you so much. Now, the another question is from Mr. Siddharth Patra. How could the accommodating approach of negotiation be best used in establishing a mutual agreement based on a consent-centric mediation process? What clashes could be avoided via this accommodating approach? And how could both the sides be balanced over a common platform when they bring out different perspectives on the same merits of the issue?
Um, there is, in most of the cases, there will always be some form of mutual ground that can be reached. Um, but as a mediator, the way that I look at mediation is that sometimes if they are not able to reach a common goal or a common place, then it's best left to time. Sometimes time plays a massive role as well. Sometimes you can take a break from the mediation process and reconvene on a later date to give them time to think, because it could be high emotions are involved, and which is why they're not willing to rethink the process. Because we have to understand, a mediation normally lasts for a day, for 6 hours, 4 hours sometimes. That's too little a time to rethink what you have thought or that all that information that you've got during the mediation process. So taking time out can be a great strategy to reach that mutual benefit, or reevaluate rather the standpoints on both the parties. So time.
Okay. Thank you so much. Now, another question is from Ms. Nandini Gore. What is the most effective way to uncover the other party's true underlying needs and priorities during a negotiation? And how can this information be used to create mutually beneficial outcomes?
talking and asking more questions is the best way to explore any party's underlying needs and positions. If a lot of the times mediators, like I said, turn into people who are just in the background listening and passing a message from one party to the other party. But if you talk and you ask enough questions, you will be able to identify if it's an interest or a need. Once you identify an interest or a need, it opens room for more options to reach a resolution, as opposed to it being someone being fixated on, no, this is the only way I can resolve this. So if you are going to explore someone's needs and interests during a mediation process, you are more likely to have more creative resolution, as opposed to not discussing it and someone saying it's either this or nothing, and then we will leave it at that, and that's a failed mediation.
Okay. So another question is from Ms. Abha Sharma. That is, what is the relationship between the negotiation approach used and the long-term viability of an agreement?
If a negotiation has not been, so if a negative negotiation approach has been used, for example, an accommodating one or a compromising one, the long-term viability of that agreement is going to be unsatisfactory, because one of the parties who had to compromise or who was at the position of power imbalance will still have that dispute in their mind in some way or form. While yes, I am aware that once a mediation has been reached on and the settlement has been agreed on, that agreement is final, but there will still be, it wouldn't still be a successful mediation, because there will still be some form of bitterness towards the other party. So there will be dissatisfaction. And like I said, that the party who felt dissatisfied through the mediation process because the negotiation was not done in a positive manner could call on there being some discrepancies on the mediator's behalf. They could accuse the mediator for being biased, for not helping them negotiate in a correct manner. So that's why a negotiation strategy is important. The correct negotiation strategy is important.
Thank you. Thank you so much. So another question is from Ms. Prabha Swami. She says that, ma'am, you have been involved in the drafting of Mediation Act 2023 and have been practicing in UK. She would like to know your opinion, given that the UK does not have a single comprehensive legislation on mediation, unlike India, which has recently enacted the Mediation Act 2023, though it may still be evolving and not yet a complete code. What in your view is a more effective model for promoting and institutionalizing mediation? Is it the codified statute-driven approach India is pursuing, or the more fragmented but practice-oriented framework followed in UK?
I would say it would be a mix of both. There's a, based off of the act that was put in place in 2023, some of the things mentioned on the act are a bit more rigid, which in my opinion are they don't match with the voluntary aspect of mediation. But at the same time, if we leave it to just exploring it, there are the options or the suggestions of sometimes people not choosing mediation or taking mediation seriously can also happen, which sometimes happens with the UK's law approach. So I think a mixed blend of both is important. In the UK, there's CMC, which is the Civil Mediation Council, which is very heavily involved with the UK law and the UK government. So even the UK government does court mandated mediations, but it is not as firmly regulated as the Indian mediation will be as per the Mediation Act. But it is regulated in the UK.
Okay. Thank you so much. Now, the next question is from Mr. Rajendra Mishra. In the context of India, at least if court directs the parties to first try mediation, can it also for both the parties, do they have to be cooperative and positive about the process?
No, because mediation is a voluntary process, they cannot be forced to be cooperative. and they cannot be forced to partake in the mediation process. A lot of the times, like I said in my presentation, a party will partake in the mediation process to tick that checkbox and say, I went to the mediation, but they will use delaying tactics during the mediation to ensure that they still get their time in court. So it depends on the mediator on how they can make that mediation successful by removing the blockage, because it's a form of blockage. If someone is partaking in the mediation with the intent of not voluntarily being present, that's a blockage, and that's the mediator's responsibility to obviously work through. But no, it's not compulsory. You cannot force someone to partake in mediation, even if it's court mandated.
Okay. So now the next question is from Mr. Ajay Lal. He asks, how does Radanks ensure that its mediation process aligns with international best practices while remaining adaptable to the cultural and legal nuances of domestic disputes in India?
So at Radanks, like I said, we are very oriented on sector-wise mediation and culture mediation, and the focus on how culture affects the process of mediation is something we hold multiple classes on, professional development courses on, and we discuss it at great lengths. A lot of our mediators are international mediators who conduct cross-border mediation, so they're well aware of the different cultures across the world. And that's how Radanks maintains the quality, because our training takes into account the different cultures and aspects of mediations across the world, including laws of the countries. And our mediators who facilitate the mediation are well aware of the cultures and the regulations across the world for whichever jurisdiction they're mediating for.
So now, thank you so much, Adamya. Now the next question is from Mr. Danish Qureshi. He says, ma'am, what is the scope worldwide in the field or era of mediation to resolve alternate disputes resolution, world going towards the position of settlement to create some betterment and effectiveness of the mediation?
Mediation has been predominantly used for family disputes as is across the world. At the moment, what the world is promoting is more civil and commercial mediation. Mediation has always been used, even in terms of, like you gave the example at the beginning of the session, you talked about panchayats in India. Panchayat in India is an old school form of mediation where a third party is involved in resolving the dispute. It's more evaluative mediation sometimes, in the form of panchayat, but panchayats have been mediating for years on end. So mediation has always been active. It's active in commercial settings as well. It's active in workplace settings. HRs conduct mediations in big corporations all the time when there's workplace disputes. It's just about bringing this to the civil world when there's more discussions about a service provider didn't provide the service. Rather than taking them to court for £5,000, you would rather mediate for that small amount in the grants. Yes, £5,000 is not small, but still in the grand scheme of things for courts, it is still a very small dispute. So that's where the mediation is going. Mediation is already very proactive and has always been an active mode of dispute resolution for family disputes and other forms of disputes. I hope that answers your question.
Thank you so much. Now I think we are running short of time. So the last question is, this is from Miss Arushi Jindal. She says, my question is, oftentimes, for instance, in divorce settlement matters, the parties can be at odds with their final positions, and a mediator can be required to step in and establish or suggest a midpoint. In such situations, how can a mediator enhance party autonomy so that they do not feel that a settlement has been imposed upon them?
I would always say playing the devil's advocate, because there are times where you need to subtly guide a party into an agreement. And the way I do it is I play the devil's advocate and I say, do you think this would be something that you will be willing to do? Do you think, ask them what their opinion is? That is the best way to do it without letting them lose their autonomy, without them thinking that it's you who has stepped into that resolution process. You can simply say, what do you think? You said this is what you wanted. or you said this is where you would want to settle disagreement on, do you think you would be willing to explore this? It's mediation. You will be a better mediator the more you practice, and which is why Radanks organizes role plays every month, because we invite seasoned mediators and novice mediators to come. We hire role players who act like real life and enact real case difficult scenarios for you to practice. So the more you practice as a mediator, it will come to you naturally, and to know exactly how to partake in it without taking away the autonomy of the parties.
Thank you so much, Adamya. I extend my heartiest gratitude to the guest faculty, and special thanks to the team Nivaran, Mr. Santhanam sir, Rakesh Khanna sir, Jitendra Sharma sir, Rajiv Datta sir, and Aruneshwar Gupta sir, and Miss Nandini Gore. I also thank member of our technical team. Without them, we wouldn't have been able to do anything. They have done a wonderful job. So I thank Rahul, Rohit, and Keshav for doing a wonderful job. And I request all of you to participate in the 5th day of 6th virtual session on mediation. That is tomorrow, 5th August. The topic for tomorrow is overview of conflicts, styles, management, and resolution. Guest faculty will be Shri J.P. Singh, Senior Advocate and Senior Mediator, Delhi, and the host for the day would be Ms. Diksha Mehrotra. So I request all of you to join tomorrow at sharp 5 p.m. Thank you so much. Thank you everybody present, and namaskar. Good day to everyone.
Thank you.
Thank you,
Adamya.
Adamya.
Well done.
Thank you so much.